relating to the new and amended jurisdictions arising from the passing of the Industrial Relations and Other Legislation Amendment Workplace Protections Act 2025, amendments to the Industrial Relations Act 1996. I'm Justice Panakulam. I'm the Deputy President of the Commission. This evening's presentations are both here in person, and we also have almost 300 people online. So welcome to you too if you're watching us in cyberspace. For the people in the room, can I perhaps just ask that if you've got empty seats to the right, can you perhaps shuffle down so that latecomers can sit in the chairs that are on my left? Thank you. Thank you. So this evening's presentation will focus on two new jurisdictions which commenced on 13 October 2025. So Chapter 3A Part 2, Prohibition on Sexual Harassment, and Chapter 3A Part 1, Stop Bullying at Work. Both jurisdictions create new powers. In respect of sexual harassment, the Commission can make orders to prevent and remedy sexual harassment in connection with work. And in respect of bullying, the Commission can make an order to prevent bullying at work, a stop bullying order. Commissioner Webster and Commissioner Muir have led the process of standing up these new jurisdictions. Commissioner Webster is going to speak about the sexual harassment jurisdiction, and Commissioner Muir will then speak about the bullying jurisdiction. We have a fair bit to get through this evening, so without further ado, let me introduce Commissioner Webster to talk about sexual harassment. And if there's a very brief time for questions, we'll do questions for both speakers at the end. So, Commissioner Webster, Commissioner Janine Webster, has been serving on the Industrial Relations Commission of New South Wales since her appointment in 2018. Prior to this, she was Chief Counsel and Executive Director at the Fair Work Ombudsman, where she played a pivotal role in shaping fairer Australian workplaces. Before joining the Fair Work Ombudsman, Commissioner Webster was a barrister specialising in employment and industrial law. Can you please welcome Commissioner Webster?
Thanks very much. Just by way of overview of both jurisdictions, there's some important differences between the two, and we thought it'd be a good place to start with what's the same and what's different. So these provisions came into effect on the 13th of October, and both are broadly similar. It does create for both jurisdictions a one-stop shop, and what I mean by that is, unlike in other jurisdictions, say in sexual harassment matters, where you might go to the ADT, there'd be investigation and then you'll go elsewhere, everything happens within the confines of the Commission, so both conciliation and arbitration. In terms of coverage, first of all, who can bring a claim? So the person who is aggrieved, if you like, in both are able to bring a claim. Both claims, an industrial organisation can also lodge on behalf of that person, or persons, so more than one as well. The coverage is slightly different as between the bullying scheme and the sexual harassment scheme. Without going into too much detail now, because we will talk about this a little bit later in our respective speeches, the sexual harassment scheme is slightly narrower in that it does not include people who are working for sole traders and partnerships, part of that cohort which will refer to the federal scheme. Bullying does encapsulate that. Whoops. Both include remedy provisions with potential damages of up to $100,000, but the basis upon which that will or can be ordered in each is slightly different as well. The bullying regime, we are looking at it needing to be aimed at stopping or preventing bullying for the future, whereas it can be awarded generally as damages in the context of the sexual harassment regime. Also, in respect of a direct prohibition that exists in respect of sexual harassment, so I'll take you to section 44N shortly. So of and within itself, it is a civil remedy provision. That's not the case with bullying. Rather, and this exists with respect to both schemes, a civil remedy, a civil penalty might be imposed in circumstances where there is a breach of an order that's made through those processes, both through the Commission. For both, the civil penalties that might be imposed are the same for a contravention of an order, and that's $18,870 for an individual, or otherwise $93,900. Again, in respect to sexual harassment, often within itself it's a standalone civil penalty provision. But I'm going to talk to you specifically about the prohibition on sexual harassment at work. As I've already indicated, Section 144N is what I call the primary operative clause, and it's what prohibits sexual harassment in the workplace for those that it covers. So it says a person must not sexually harass another person, the protected person, in connection with the protected person being an employee, and then there's a broader definition, if you like, going beyond that, a prospective employee, or a person conducting a business or undertaking, which seems a little bit strange. We assume that that person is a natural person who's conducting a business or undertaking. Who does the sexual harassment prohibition apply to? As I said, it applies to an employee, a prospective employee, and that person conducting a business or undertaking. But perhaps more importantly, and where I think most people should start in trying to work out if they can come to the Commission, who is not able to bring a claim, and that is a national system employee. And as I indicated earlier, what that means for sexual harassment is that people are able to bring a claim in the federal jurisdiction. So this jurisdiction really plugs that gap where a matter is unable to be taken to the Fair Work Commission. People can bring a sexual harassment claim to the Fair Work Commission who are a national system employee, which does cover those that are engaged by partnerships and sole traders. Those persons are referred by the Industrial Relations Commonwealth Powers Act 2009, and therefore it does not cover those individuals. I should also mention that an employee has a broader definition as well. And an employee includes, and I won't go through the full list, but it includes the likes of contractors, subcontractors, outworkers, volunteers, and so on. In terms of who can apply or who can bring a claim forward, there is a 2-year time limitation in terms of matters that can be commenced. As many of you would know in this room, there are other places. This is a complementary jurisdiction. A person who can bring a claim to the Commission might be able to bring a claim under New South Wales legislation and so on, but you have to choose. You can't bring concurrent claims if you like. However, you can bring a concurrent work health and safety claim. I've already mentioned those that have standing to bring a sexual harassment matter, so the aggrieved person themselves can bring it, but also an industrial organisation, and again, that can occur in respect of a number or a group of people. Now, what must be established to make a valid claim of sexual harassment? So what the legislation does through Section 144L is it picks up the definition of sexual harassment in the Anti-Discrimination Act 1977, so through Section 22A1, and it is in the following terms: a person sexually harasses another person if the person makes an unwelcome sexual advance or an unwelcome request for sexual favours to another person, or the person engages in other unwelcome conduct of a sexual nature in relation to the other person, and finally, the conduct, advance or request occurs in circumstances in which a reasonable person having regard to all of the circumstances, would have anticipated that the other person would be offended, humiliated, or intimidated. Because the state jurisdiction has picked up on this definition, and it's the same in the Fair Work Commission, the Fair Work Act as well, perhaps helpfully, the jurisprudence that has developed around the definition of sexual harassment there is going to be instructive in terms of any cases that are brought here in the Commission as well. And obviously there is quite a lot of jurisprudence and case law that has developed there. The case also, consistent with the state legislation, talks about circumstances that must be taken into account in determining whether or not sexual harassment has occurred. It includes the sex, age, sexual orientation, gender identity, intersex status, marital and relationship status, religious belief, race, colour and national or ethnic origin of the other person. I've emphasised here because I think it's particularly relevant, all is relevant, but the relationship between the other person and the person who made the advance or request to engage in that conduct. For example, where a person has already had a relationship with a particular individual, you can imagine that kind of circumstance coming up, and here the Act specifically states that will be relevant. A disability, if any, of the other person, and another relevant circumstances. So in other words, any of the relevant circumstances that the Commission might think is appropriate to be taken into account. So it's not a limited to, I guess these are just matters that the Commission is directed to. So effectively, in establishing sexual harassment, there's 3 points of proof. The first of the 2 elements are questions of fact. So the first and second, one of the 3 forms of conduct identified in section 22A1 occurred, namely a person engaged in one of those 3 things. The second, if such conduct is found to have occurred, it was unwelcome. Both matters are fact to be determined on the Briginshaw standard of proof. The second is to be derived from the subjective feelings or evidence of the individual against whom the sexual harassment is said to have occurred. The third element is the unwelcome conduct occurred in circumstances in which a reasonable person would have anticipated the possibility that the complainant would be offended, humiliated and intimidated by it. So the third question effectively limits the ambit of the definition by an objective criterion and will need to be considered within that context. I just want to make this point really clear, and that is that there will need to be a high level of precision in terms of identifying each of these elements and bringing these matters, because it is effectively not only the gateway for the Commission being able to then make any orders, which I'll come to shortly, but it's also a gateway for there being able to be made a claim for a civil penalty remedy as well. So I think particularly in our jurisdiction we try to be accessible to a broad remit range of people, including lay advocates, but where something as serious as this is being alleged and the consequences are that capacity to bring that other application in the court as well, it will be necessary to be thoughtful and to think through each of the elements and indeed each of the occasions upon which the harassment is said to have occurred. And this is, again, one of the points of distinction I'd like to make as between this jurisdiction and bullying. Bullying talks about there being a pattern of conduct, whereas it might just be one act or one thing that happens which constitutes sexual harassment. And so therefore, you might be identifying a pattern, you might be identifying several acts on different occasions that have occurred. So I think it's important to be clear about how many breaches you claim there are as Section 144N. And that may be relevant in terms of any future application for the imposition of a civil penalty. This legislation also provides for vicarious liability. So specifically, section 1440 provides that a person contravenes section 144N if the employee or agent of the person does an act that contravenes section 144N, which we've just been talking about, and the act is in connection with the employment of the employee or the duties of the agent as an agent. And I emphasise those words in connection with because that has been a matter, again, which has arisen in other jurisdictions, and the extent to which that draws in matters which are tangential or outside directly the workplace, but have that connection one way or another. I just note that subsection 3 provides, I'll call it a defence. It says that this section does not apply if the person proves that the person took all reasonable steps to prevent the employee or agent from doing acts that will contravene section 144N. It has to be positively asserted or pled. So the onus is upon the employer or the agent to make that claim. And in terms of that, again, we have other jurisdictions to draw upon in terms of what that might look like. All reasonable steps need to be taken, not just some. And it doesn't mean that every conceivable step needs to be taken to prevent a person from doing the unlawful acts. But again, it means that all steps that are reasonable must be taken. It's obviously going to depend upon the circumstances of the individual workplaces, including the organisation size, the nature of the workforce, conditions under which work is carried out, and the history of sexual harassment. So it might not just be enough to have in place a policy. You might need to show that it's refreshed, or employees are reminded of that on a regular basis. And indeed, you might need to show that it's not just lip service, and that when there have been contraventions or issues raised in the workplace, there's been some leadership to demonstrate that it's real and it will be acted upon. So these are the types of things that I imagine many of the organisations that we regularly see here would be grappling with and thinking about at the moment. Excuse me. So moving on to remedy. The Commission's been given a very broad discretion to make orders by way of remedy. So just to make clear, you've got the section 144N contravention is the gateway. Then we look into remedy. It's a may. It's not a must. And so, all of those kind of matters that you would consider in the context of House and the King, taking into account all of the matters that are relevant but none that aren't, will be important. There is a specific list of the types of orders that may be made, and I've listed them here. They include things like an apology, damages for an employee of compensation to a maximum of $100,000, and I will come back to this. A prohibition on continuing and repeating the sexual harassment, so forward-looking, the performance of reasonable actions or course of conduct to redress loss and damage, an apology, and the introduction of a program or policy to eliminate sexual harassment moving forward. I do note that the order may apply to either the individual who engages in the sexual harassment or the person vicariously liable under the IR Act. Matters that are relevant in determining remedy, these are matters that the Commission must take into account, and they include what else has happened before the matters come to the Commission. So other grievance or dispute procedures that are available to the person that the Commission's aware of. I'm not really sure why that language has been adopted, might be aware of. Outcomes, either interim or final, the Commission is aware of from other investigations, dispute resolution procedures, and any other matters the Commission sees as relevant. In terms of the remedy, I just note that the general law principle in damages is applicable here. So the concept of putting the applicant back in the position that they would have been had the wrong not occurred, that you would anticipate would be the guiding principle. Importantly, and unlike the unfair dismissal jurisdiction, it includes both economic and non-economic loss. Non-economic loss being humiliation, damages for humiliation, and so on. So I did want to mention that although you can have an order including for damages against both an employer and agent as well as the individual who has committed the wrongs, you do need to establish a causal link between what the employer or agent failed to do and the losses that are sustained. So one would not expect there to be a process of double dipping, if you like, whereby an employer would be compensated twice for that wrong by each of those parties. Can't emphasise this enough. It is essential that there's evidence to support a claim of damages. And that point's been made in other jurisdictions very clearly. So I think, again, I'm drawing that parallel because a lot of the processes will be similar, which I'll come to again shortly, with our other jurisdictions. But often I find in our matters that the issue of remedy is forgotten or it's a bit of an afterthought. Whereas here, if an applicant is wanting to make a claim for significant damages based on psychological injury, for example, psychosocial injury, you will need to bring proof of that, which means relevant reports and the like to sustain that, and also in terms of future economic loss as well. When can an order for civil penalties be imposed? I've already touched on this a little bit. Again, Section 144N is a civil remedy provision of and within itself, but it is stated in the Act that an application for a civil penalty order for an alleged contravention made of Section 144N must not be made unless a sexual harassment order has been made for the same or substantially the same conduct constituting the alleged contravention. So you have to come to the Commission first and get an order before you can go and make an application for a civil penalty in respect of the same or substantially the same conduct. There could be more than one contravention arising out of an application. So hence, as I've already emphasised, the importance of being clear about what constituted the breach of Section 144N and how many contraventions you say there are. Additionally, Section 144U provides the industrial court may impose a penalty if a sexual harassment order has been contravened. So that sits separate as well. And I've already told you about the maximums that apply there. Okay, so if you forget everything else that I've said to you today, which is not uncommon, please remember that Practice Note 35, Sexual Harassment Applications, has been published on our website, and it is very important whether or not you be an applicant or a respondent or representing such a person in these proceedings. It applies to sexual harassment applications, as I've been talking about today, but it doesn't apply to the civil penalty proceedings. That is separate and different. I'm not going to read it all out to you now because I know you're going to go home and dutifully study it, but it does encourage workplace resolution, as does the bullying practice note, but there is that appropriate language around only if it is safe to do so. I think one of the points of departure between what you would be experiencing the Commission in this jurisdiction and others is that the procedure may be a little bit different, and I'll talk to you a little bit about that. We can adopt our own procedure, and Rule 4.9 provides for that. It's also set out quite explicitly in Practice Note 35 as well. One of the things which is a little bit different. It is completely different from bullying, but different from our broader jurisdiction, the requirements around service. So it's provided for in both the practice note, but perhaps more importantly in the rules, that the registrar must serve the application on any person the application identifies as having engaged in sexual harassment, and the employer or principal of any person the application identifies as having engaged in sexual harassment. And that's at Rule 35 of the amended rules. In respect of sexual harassment matters, there is a requirement for respondents to file a response, again, different from bullying. We do also have a power, the Commission, to either join or remove respondents. So that's in anticipation, well, I guess two types of situations. One is the scattergun, where everyone's been included in a complaint, and that's not necessarily appropriate, and equally where you might have an individual who doesn't understand the requirement to include both the individual against whom the harassment is alleged and also their agent or employer. So that can be added in. Okay, so how are these matters going to be resolved by the Commission? Our guiding principle will apply, as it does to all of our matters in the Commission. We aim for the just, quick and cheap resolution of proceedings, and we take that really seriously. So that's the manner in which, or that will be our guiding principle with respect to these matters as much as any others. And you will expect with conciliation that these will be dealt with very quickly. So if one compares it to the experiences in other forums that deal with harassment matters, this is a departure. It will be quick. It will usually be within 21 days of commencement that you will be sitting in a room, either real or virtual, with the complainant. There is capacity for different arrangements to be put in place. Obviously, we're conscious of the nature of the allegations and allowing people to have the discussions in an appropriate way, but also in a manner which doesn't exacerbate any issues that person might have experienced. It could be done via AVL, and again, if you look at the practice note, that'll give you some guidance in terms of how to make those applications if you feel that it's appropriate to do so. The Act actually provides that if conciliation fails, then you do move to arbitration. So you either dismiss the matter or you make orders. So you can expect that the usual directions will apply. So most of our matters are what I refer to as a single event solution. We have one conciliation within 21 days, and at the end of that, if it fails, it'll move into arbitration with directions being made there and then. That will happen in these matters as well, with exception if it's appropriate, depending on the discretion. It will remain within the discretion of a particular member who's considering the matter, of course. And as I've indicated, your civil penalty proceedings are separate and different. They're not a part of this. So last word on this jurisdiction. So these are my tips for sexual harassment matters at this point in time, and before we have in fact received any. Again, I'd ask that you familiarise yourself with the practice note, also the new rules, and I should also mention that this matter comes with new forms as well, that again look a little bit different to the ones that you're accustomed to. It does actually push parties towards providing that information that I've already articulated will be quite important for us to be able to determine these matters properly. For applicants, particularise the alleged conduct as far as possible. Is there one or more contravention alleged in respect of section 144N? For applicants, be conscious of your ethical obligations in threatening other action to gain leverage in negotiations, such as reporting matters to the police to try and get more money through a money claim or through a damages claim. For applicants, deduce evidence relevant to damages. So if you're going to be claiming future economic loss, if you're going to be claiming psychosocial injury, that needs to be properly done with evidence. Individual respondents consider whether criminal and penalty privilege might apply, and for employers and principals, take all reasonable steps to prevent sexual harassment in the workplace before there is a claim, to state the bleeding obvious. And that's it. That's the last word on sexual harassment orders, and if there's any time, I'm happy to take any questions at the end.
Thank you, Commissioner Webster. Commissioner Muir is now going to take us through the new bullying jurisdiction. Commissioner Christopher Muir was appointed to the Industrial Relations Commission of New South Wales in 2021. Before being appointed to the Commission, Commissioner Muir had worked in both the public and private sectors, including in private legal practice, in corporate roles at an ASX-listed entity, and in regulatory supervision at the Australian Transaction Report and Analysis Centre. Immediately prior to appointment, he was CEO of an industry association. Please welcome Commissioner Muir.
Thank you, Justice Manacklin. I have the easier task for tonight in that a lot of what has been said applies to bullying, and I largely will attempt to avoid going over that because it's almost word for word the same content. I'll start with some preliminary thoughts. The focus of the jurisdiction is an attempt to create safe workplaces by stopping bullying conduct. Note that there's no general prohibition on bullying, unlike sexual harassment. To make an order, there must be a risk that the applicant will be subject to further bullying. That means it's likely that the parties will still be sharing a workplace. It's almost by definition they'll need to be continuing to share a workplace. There is no time limit. That makes sense in the sense that this is a forward-looking jurisdiction only, not it will look to past events, but the purpose of it is to create a future without the bullying conduct. It goes without saying, and this is probably not different from sexual harassment claims, the participants are likely to be emotionally invested. The Commission, as with sexual harassment, must consider workplace processes and other investigations, and I'll come back to some of that shortly. A reminder of this slide, which covers the bullying jurisdiction. I won't labour the point on that. Commissioner Webster's taken you through that. Who can apply for a stop bullying order? The legislation says an employee who reasonably believes they have been bullied at work can apply. I don't know that there's particular magic in the phrase the employer who reasonably believes, or whether that's just the way in which the legislature has expressed that someone who thinks that they've been bullied can apply. An industrial organisation can also bring an application on behalf of an employer or on behalf of more than one employee. It's probably worth reiterating that the Commission has the power to join matters and to separate them regardless of how the applications come in, and that's set out quite explicitly in the legislation. Because the Fair Work Act says that employee in the bullying sections of the Fair Work Act has the ordinary definition of employee rather than the national system employee, for reasons which are not obvious to me, bullying was not included in the Fair Work Act regime for unincorporated bodies, and this legislation therefore picks that up because, as Commissioner Webster has explained, we start with employee having the wider definition of worker in the Work Health and Safety Act, and then we say anyone who can bring a Fair Work Act claim may not bring one here. As with the slide that we had for sexual harassment, there's a slight difference here in that there's no time limit, but there needs to be a risk of continuing bullying. It in itself is a time-limiting factor, I guess, because if there's no risk of future bullying, then we are talking about something that must be a fair way in the past. As with sexual harassment, we can't have multiple actions under anti-discrimination law, but we can pursue work health and safety claims at the same time as pursuing a stop bullying order in the Industrial Relations Commission. The definition of bullying is a pretty standard one. Employee is bullied if, while at work, an individual or group of individuals repeatedly, and that's the difference from sexual harassment, behaves in an unreasonable way towards the employee, and that behaviour creates a risk to health and safety. Subsection 2 is again a fairly standard expression that reasonable management action can carried out in a reasonable way, and they've managed to get reasonable into that section twice. It probably is simply there for clarity, because if someone carried out reasonable management action in a reasonable way, they wouldn't be behaving unreasonably towards someone, but I think it's helpful that it's expressly set out. There's no definition of at work in the provisions. Obviously, at some point we'll come across an edge case, but I assume that in the early days that most of our cases will be pretty clear whether it's related to work or not. The definition of bullying is substantially the same as under the Fair Work Act. It means that, as Commissioner Webster has pointed out, the decisions of that body will be of help to us. I put up an extract from the Fair Work Commission in MAC and Bank of Queensland, which came up with a fairly extensive list of the kinds of actions which might go towards something being bullying behaviour. It's not exhaustive, notwithstanding its length. It's just that the conduct must be unreasonable and create a risk to health and safety. We have a new form. We do love a new form in this place. We have Form 63A. It is more detailed than some of our pre-existing forms. As with sexual harassment, it guides applicants to describe in more detail certain conduct, time and date, what happened, in a little more detail than we normally do, which is to leave it rather at large. I won't read out the rest of the slide, but it's important that it's understood. It's probably not quite the same as sexual harassment in the sense that it doesn't need to be quite as specific. It is much closer. This is probably much closer to some of our standard procedures, and there will have been decisions of this Commission that fundamentally deal with bullying that will be able to be referenced. Responding to the application, I've noticed I haven't got the same font size as you had, Commissioner Webster, so that may be harder to read. There is a new form for the respondent. Different from sexual harassment, the employer must file and serve a response. That is, the employer the person alleged to have been bullied, alleged to be the bully, may file a response. That's partly a learning from discussions we've had with other tribunals who've dealt with this matter, in the sense that preventing bullying in the future is more likely to be productive if we get the employer on side. Perhaps it would be helpful to get the alleged bully on side, but it's not necessarily, we could expect that an employer will take that responsibility. I should go back a step. The applicant will need, in the normal way, to serve the application on the respondents. Unlike sexual harassment, we're not taking that on in relation to bullying applications. This is the same slide. You can see it's the same process that we'll go through. It's the same process we usually go through. The Commission can make an order to stop bullying if it finds that the employee has been bullied at work and there is a risk the employee will continue to be bullied at work. It's a risk. It doesn't say it's a probability. It's a risk, so that's obviously a lower threshold, but there must be a positive finding that there's that risk of future bullying. The bullying order can be made as is practical against the alleged bully, or by this point the person who's been found to be a bully, the bully's employer, etc. In determining the order, the Commission must take into account three things: other grievance or dispute procedures available to the employee that the Commission is aware of. In some sense, it's almost inevitable that the person who's made the application has found those processes inadequate but the Commission is required to take those into account. And also outcomes, whether interim or final, from investigations into the conduct of the subject of the application. Presumably that means one's conducted by the employer on the whole, given that there's a prohibition on concurrent discrimination complaints as well as to the Commission. And curiously, we must take into account other matters that the Commission considers relevant. The Commission, as with sexual harassment orders, is empowered to make any order it considers appropriate, and then the legislation sets out some examples. I'll come back to damages. The others are, on their face, reasonably obvious kinds of things that the Commission might order. It's a prohibition on repeating the behaviour, reasonable actions or courses of conduct to redress the loss or damage. I would actually hold that thought with the damages perhaps. An apology or retraction, and the introduction of a program or policy aimed at eliminating bullying. The issue with damages, and perhaps to some extent an apology or the performance of reasonable actions to redress loss or damage, is that the Commission must make an order in order to prevent future bullying. It's not necessarily obvious how an award of damages would do that. So that's an issue that applicants who want damages are going to need to address. Presumably that will be one of the first things that we'll have to determine when the applications start to be arbitrated. As with sexual harassment orders, a stop bullying order, if it's not complied with, is the subject of the civil penalty, which you'll need to take to the industrial court. As with sexual harassment orders, there's a new practice note. I do recommend that to you. It's more detailed and more thorough in its content. It will go through all of the different processes. It does encourage workplace resolution if safe, but as I've said, in terms of considering workplace procedures, the fact that someone sees fit to bring an application here almost by definition suggests that they don't think that that process is safe. That's all I wanted to cover. As I said, I had the easier task today because much of it's been covered. Sorry, the one last thing I did want to cover, the damages section the Commissioner Webster went through in detail, equally applicable here. I'm not going to repeat those provisions. I think we're ready to have questions.
So, do we have any questions from the floor? Yes?
Thank you, Commissioners, for that presentation. Commissioner Muir, with the presentation that you just delivered here on stop bullying, I know that there were an opportunity to have multiple respondents attached to that form. Noting a comment about there might be an instance where you can serve that application to the bully, maybe not necessarily serve the employer. I guess what I'm wondering in that particular scenario, I'm not asking necessarily to envision one, I would envision these processes where I guess the employer might not necessarily undertake all reasonable steps to therefore put us into a situation, an applicant into a situation that might do that. So are there some scenarios where it's just the bully and the applicant, or we would be necessarily looking at two respondents at all times, like a bully and the employer, because I envision it within, I guess, work health and safety situation. So thank you.
So for the benefit of those online, the question is, in a short version, is what happens if an application is made for a bullying order only against the bully and the employer is not added? I guess procedurally the Commission should hear from both parties about whether the employer should be added. I guess we've assumed that in the majority of cases that's the appropriate course for a whole range of reasons, some of which I covered, including that the employer is probably in a position to enforce future conduct. But I don't know that we'll have to wait and see what the particular circumstances are. But as I say, it's assumed from our end that the employer would ordinarily be a respondent one way or another.
Yes?
Is there an expectation that an employer has completed an investigation by the time they come up for consideration?
The question was, is there an expectation that an employer will have completed an investigation? The legislation doesn't have any kind of presumption of that kind. I don't think in the procedures we've created with there's an expectation. It will depend how long into the process. If it's a sexual harassment claim, it may be that the application is made quickly after what constitutes sexual harassment has happened, so there's no time for an investigation. If there's bullying, I guess I have a sense that it's more likely to be later in the process, but I can't say that I think that it's going to be one way or the other. The bullying kinds of applications that where they've fed into an industrial dispute or an unfair dismissal, largely there's been a long history, so I don't know that I'd call it an investigation in every case, but I suspect that there's likely to be, it's the public sector, there's likely to be a process and it's likely to have been resulted in something if there's been a reasonable history to the matter.
I guess with respect to sexual harassment matters, I don't think that the legislation requires or anticipates that, and in fact I envisage that there may be matters where, in those matters, perhaps more than bullying, where more likely it might be the first time that the employer learns about this is when they receive a copy of the application. I do, however, note the requirement for the Commission to take into account other investigations and grievance processes in the context of determining an appropriate remedy. But I guess it's quite difficult to anticipate all the different circumstances that might come before us. But I can't imagine, if the employer is unable to complete that investigation prior to the matter being filed, that would be a reason not to award damages, for example. Does that answer your question?
Yes, the follow-up question would be, is that something that the Commission would consider in, say, during the litigation?
I think that will very much depend on the application itself. Okay, sorry, I didn't repeat the question. So the question for those following at home is whether or not, if the employer is partway through an investigation, whether or not it's a matter that might be taken into account for the purposes of deciding if the proceedings should be adjourned. So I think it's just too hard to know without having that kind of before us. What I would say is, from again learning from other tribunals with like jurisdictions and drawing upon our own experience, is that particularly with sexual harassment matters, there might be, we're anticipating that there will be more separate and different perspectives being put before the Commission. So where the employer is condemning the conduct, if you like, or has done so, whereas with bullying experience in other jurisdictions is that often there has been an investigation and they will be jointly represented. Again, I'm not sure if it directly answered your question, but I think that we'll see how it unfolds.
Yes, Ross.
Thank you, President. The question for both jurisdictions, the legislation contemplates that when determining orders, the Commission needs to take into account a number of things. And you touched on this, Commissioner Webster, to a certain extent. You're intrigued by the use of the words, things that the Commission is aware of, for instance, or investigations. So does that contemplate, and I'm thinking two scenarios, does that contemplate that potentially there may not be investigations that the Commission is aware of, or does that contemplate that if investigations and grievances aren't brought before the Commission as part of the proceedings, then that's not something that will be considered?
So the question focuses on the wording that the Commission must take into account investigations or processes the Commission is aware of, and it's On its face, it's a slightly unusual wording because A, the Commission would normally be expected to act on evidence, not bound strictly by the rules of evidence. It may simply be that that's the way it's been expressed and there's nothing particular about it. I can't immediately think of a circumstance where the Commission's aware of something, but that's not through someone giving proper evidence of that fact.
But I think, Ross, so what your question coming at is that potentially there will have been a process and neither party puts that before the Commission.
If it's unrepresented applicants or it's just a respondent submitting particular evidence or not,
And I must admit, I hadn't thought about, I was curious about the wording of that provision and why that wording was used, and maybe that's why, is that potentially both parties will choose not to put before the Commission a process that's already kind of concluded, and maybe that's why it's worded that way, but we'll find out. Another question?
Yes?
I believe there's one bullying application that's been filed, but does anyone have any more information? And Commissioner Muir has that matter, so he can share all of his insights. Yeah.
I can, but on Wednesday.
Yes?
Thank you, President. So the Act contemplates that to make a stop bullying order, the Commission is to be satisfied that there is a risk that the employee will continue to be bullied at work. Do you anticipate that in arbitration proceedings, the Commission could accept evidence in the form of assurances by an employer of actions it will take to prevent that from happening, as opposed to actions of things that it has already done?
It's really a question of what the Commission's persuaded of, that a process, a change in management line, a commitment to something, whether that is that removes the risk. How successful are you in persuading the Commission that all of these changes remove that risk? And sorry, I should say, the question was to what extent an assurance by an employer that procedures are in place or that new line management would remove a risk.
Mr. Dancy.
What capacity does the Commission have to do recommendations or directions before a finding of bullying has been made? So will it be similar to the dispute where the Commission will have the ability to make recommendations and directions before a finding of bullying has been made?
So those arise in a particular context of Section 130. Sorry, the question was, can the Commission informally make recommendations, presumably in conciliation? I see it, I suppose, as the same as an unfair dismissal application. There's no statutory power to do that. Presumably, some members of the Commission do that in certain matters because one of the parties says they'd like a different commissioner to do the arbitration.
Just for my own part, some of you might know I sometimes make recommendations in unfair dismissal matters, and I just think that we are able to do that within the existing framework. So I wouldn't, if it was appropriate and I thought it might actually bring the parties to an appropriate resolution, I wouldn't hesitate in doing that, even if it isn't specifically provided for within the words of the legislation itself.
Yes?
Commissioner Webster, in the sexual harassment jurisdiction, it seems that the ability to, on 10
How am I going to, I'll try and, just for those that are online, so the question is around there being potential issues in terms of claiming penalty privilege in the commission proceedings where we can't order penalties there. That is constituted, that's a separate proceeding before the court. I think it's a good question. I don't know the answer to it, if I'm being honest about that. I think that those issues are very tricky, and I think they're somewhat different or unique to this legislation because it differs from what the Fair Work Act and the Fair Work Commission has, and you know, they are the types of issues that are being raised, and I think we will need to work through.
Yes.
In some serious misconduct matters, there might be investigation. The matter might involve a referral to the police for criminal charges, prosecution. So, and often there will be objection to the investigation continuing because often the lawyer might say, well, we don't want to make any admissions. So in terms of that sort of context, those sort of facts, there's a ruling of sexual harassment claim. How would the commission propose to deal with that?
The question is what happens if, in the process leading to the matter coming to the commission, the employer has referred some matters off from its investigation for the police, and what does the commission do if that's raised? It's not. The answer you get will be, in some senses, the one you expect, which is I can't tell you what will happen in any particular case because it'll depend on what the risk is, what the attitude of the applicant is, what, if any, information the Commission has about what the state of the police investigation is. It's no different from a range of unfair dismissal applications that end up in the same circumstance, I think.
Yeah, I'd just add to that it's not an entirely foreign situation, and that certainly, well, I can think of a few matters where there's been a notice of motion for a matter to be stayed pending the outcome of a criminal matter before either, you know, the district or the local courts. So I think it'll be dealt with on a case-by-case basis, and as these matters come up, then obviously we'll deal with them as they arise and on their merits.
We've got time for one last question, if there is one. No? Well, can I start by just asking you to join me in thanking Commissioner Webster and Commissioner Muir again? And can I also thank you for your attendance today, both in person and online. There's obviously been a significant amount of interest in relation to these new jurisdictions in particular. The next presentation in this series coming out of the recent amendments is in relation to changes to the work health and safety jurisdiction, both civil and criminal, and that presentation will be on the 12th of March 2026. So we hope to see some of you then as well. Thank you very much for attending this evening.